now in session. Court is in session with the announcement docket scheduled on today, January 4th of 2023. First case, court is calling is two cases. Cause number 329-372, cause number 329-374. Both cases are style of state of Texas versus Gabrielle D. Fontenot. Ms. Bailey, would you please, Ms. Fontenot? Gabrielle Fontenot. Ms. Fontenot, your full name, Gabrielle D. Fontenot?
Yes, sir.
How you doing, Ms. Fontenot?
I'm fine.
That's good, Ms. Fontenot. Your attorney of record is attorney Terrence Allison. Mr. Allison is not here, however, standing in for Mr. Allen is attorney Marius Allen. Does Mr. Allen have your permission to stand in for Mr. Allison?
Yes, sir.
And again, Ms. Fontenot, how are you doing?
Fine.
And Mr. Allen, how are you doing?
Good, how are you?
I'm doing fine, thanks for asking. State is represented in this case by attorney Lamar Johnson. Attorney Johnson, how are you doing?
I'm doing well, Your Honor, thank you.
Mr. Allen, what is your announcement in Ms. Fontenot's case?
I would like to ask this case be placed on the plea docket.
Okay, we'll schedule for a plea. Give us a plea date, February 6th or March 13th, which day is?
March 13th.
Okay, this case will be reset to March 13th of 2023. Ms. Fontenot, your attorney, Mr. Allen, is going to get your reset. Once you get your reset from your attorney, you'll be free to go and you have a blessed day. And I think Mr. Allen is the only case you, honestly, okay, you'll be free to go and you have a blessed day. Next case is cause number 331922. Case of South State of Texas versus Joshua Jeray Hines.
Yes, he's present, Your Honor. Happy New Year.
Happy New Year too. Mr. Hines, your full name is that Joshua Jeray
Yes, sir.
Hines? How you doing, Mr. Hines? That's good, Mr. Hines. You're here represented by your attorney. Attorney Kevin Lane. Attorney Lane, how are you doing?
Fine, thank you.
And Mr. Lane, what is your announcement in Mr. Hines' case?
Well, Your Honor, this is our second announcement for the same reason. We requested the tape in this case back in June 8th of 2022. I've looked to see if it's been emailed to me. I need to get with Karen. If I could just get one more announcement. I have an offer. I have all the other records in his case. Mr. Pretrial diversion, I've been denied that. I just want him to see the video and let us go from there, if that's okay.
Okay. Give us a reset date. Yeah. Okay, be reset to March 8th of 2023. Mr. Hines, your attorney is gonna stand for your reset. Once you get the reset from your attorney, you'll be free to go and you have a blessed day.
Thank you, Your Honor.
Please, reset. And the next case is going to be John Trimble.
He's present, Your Honor.
Yes, would you please, oh, he's present.
Give me a second, Mr. Allen. It's not ready.
Sorry, Your Honor, I'm sitting there.
Okay.
Kathy over there.
Court is in session in clause number 332 516, case of style of state of Texas versus John Paul Trimble. Mr. Trimble, is that your full name?
Yes, sir.
How are you doing, Mr. Trimble?
I'm doing good. How about yourself?
I'm doing fine. Thanks for asking. Mr. Trimble, you're here represented by your attorney, Kevin Lane. Attorney Lane, what's your announcement in Mr. Trimble's case?
Your Honor, I have received all the evidence. I got an email regarding the video. We've got to see the body cam of the arresting officer, but it was emailed to me and I cannot download it. Got to get with Karen. It might be on my end, it might be on hers, but it's a 7-hour download. So I would like to speak to Karen this morning on those two cases. If I could just come back maybe March 8th.
Okay.
And I can have an announcement.
Okay, Mr. Trimble, your case will be reset till March 8th. The attorney is going to sign for your reset. Once you get your reset from your attorney, you'll be free to go and you have a blessed day. And Mr. Lane, I think this is your last case, so you'll be free to go as well. And you have a blessed
Thank
day.
you very much.
All right, thank you. Mr. Jefferson County Court at Law number 2 is back in session. The court's advanced the docket. The next case is cause number 332336. The case is style of state of Texas versus Nathaniel Scott Dunaway. Mr. Dunaway is appearing via Zoom. Mr. Dunaway, you can take your mic off of mute. Mr. Dunaway, can you hear me?
Yes, Your Honor.
Okay, how are you doing, Mr. Dunaway?
Pretty good. How about yourself?
I'm doing fine. Thanks for asking. Mr. Dunaway, your attorney, Mr. Joe Vasquez, is present here in court. And Mr. Vasquez, how are you doing?
Good, Your Honor. How about yourself?
I'm doing fine. Thanks for asking. Mr. Vasquez, What is your announcement in Mr. Dunaway's case?
Your Honor, could we have 60 days in Mr. Dunaway's case?
Okay, give us a reset date. Okay, this case, Mr. Dunaway, will be reset until March 8th of 2023. Stay in contact with your attorney and your bondsman. They will be given notice of your reset date. You're free to go at this time, and please have a blessed day.
Yes, Your Honor, you too.
Okay. The next case, you said sign for the reset. Why don't you sign for the reset right now? Next case, is cause number 330-820. The case is style of State of Texas versus Celso Martinez. And, Mr. Martinez is appearing via Zoom. Mr. Martinez, how are you doing?
Doing well, Your Honor. How are you?
I'm doing fine. Thanks for asking. Mr. Martinez, you're here represented by your attorney, Attorney Joel Vasquez, who's present in court. Mr. Vasquez, what is your announcement in Mr. Martinez's case?
Your Honor, could we have another 60 days in Mr. Martinez's case as well?
Okay, this case is gonna be reset till March 8th of 2023. Mr. Vasquez, you can sign for the reset. Now, Mr. Martinez, your attorney, Mr. Vasquez, will be given a notice of your reset. Your bondsman will also be given notice of your reset. Stay in contact with your attorney and your bondsman. Your case has been reset to March 8th of 2023. You're free to go, and you have a blessed day.
Thank you, Your Honor. You too.
You're welcome.
Thank you, Judge.
Okay, you're welcome. You can go ahead and sign for your reset. Next case is cause number 330-810. The case is style of State of Texas versus Christopher Joel Gonzalez. Mr. Gonzalez is appearing via Zoom. Mr. Gonzalez, you can take your mic off of mute. How are you doing, Mr. Gonzalez?
I'm doing well, sir. How about yourself?
I'm doing fine. Thanks for asking, Mr. Gonzalez. You're represented in your case by your attorney, Dustin Galmore, who is also appearing via Zoom. Mr. Galmore, how are you doing?
I'm great, Judge. How are you?
I'm doing fine. Thanks for asking. Mr. Galmore, what is your announcement in Mr. Gonzalez's case?
We'd like to place this case on the trial docket, Judge.
Okay, just hold on for your reset date. You got 2 days, February 27th or March 13th.
February sounds better to me, Judge.
Okay. Okay, this case, Mr. Gonzalez is being reset to February 27th for trial. Your attorney and your bondsman will be given notice of your reset date. Please stay in contact with your attorney and your bondsman. This will conclude your case. You're free to go, and you have a blessed day.
Sounds good, Your Honor. Thank you so much. You too.
Thank you. And Mr. Galmore, is this your only case?
It is, Judge. Thank you very much.
Okay, you're free to go as well. Your reset will be sent to you, and you have a blessed day.
You too.
Thank you. Yeah, I know. I'm looking for it on the docket. Okay. Next case is cause number 332748. The case is style of State of Texas versus Julio Cesar Lemus Govea. Mr. Govea, would you please come forward? Come forward and stand on the X. This is cause number 332748. The case is styled in State of Texas versus Julio Cesar Lemus Govea. Mr. Govea, is that your full name?
Yes.
How are you doing, Mr. Govea?
Pretty good.
That's good. Mr. Govell, you're here represented by your attorney, Attorney Jerry Gilthorpe. Attorney Jerry Gilthorpe is appearing via Zoom. Mr. Gilthorpe, how are you doing?
Doing well, Judge. How are you?
I'm doing fine. Thanks for asking. Mr. Gilthorpe, what is your announcement in Mr. Govell's case?
Judge, we'd asked for a reset. We were applying for a pretrial diversion and we'd like to get a response on that.
Okay, let's see. When is the next one? Is it February? Okay, yeah. Give him a reset February, March. Give him a reset in April because you haven't received a response yet, right?
We have not, Your Honor.
Okay, because I know the next signing date is February. So if you haven't received a response, you won't be on the docket in February. So we're gonna give you, it's every 2 months, so we're gonna give you March, April. We're gonna give you an April date, second week in April.
Thank you, Judge. That'll work.
Okay. Okay, so this case is gonna be reset to April 17th of 2023. Mr. Govell, your attorney will be given notice of your reset date. You're gonna get your reset here in court. Stay in contact with your attorney. Once you get your reset from our court coordinator on the far end, you'll be free to go and you have a blessed day. Please stand on the far end. And Mr. Gilthorpe, your case will be, your reset will be sent to you. And I think this is your only case, so you're free to go and you have a blessed day.
Thank you. Same to you, Judge.
All right, you're welcome. And at this time, and Grace. Okay,
That's two, part one.
is that Yeoman Day?
Done.
Die? Okay. Next case is cause number 329224. Case is style of state of Texas versus Yeoman Die. Mr. Die, would you please come forward? Mr. Die, is that your full name, Yeoman Die?
Euban, yes, sir.
Euban Die?
Yes, sir.
How you doing, Mr.
How
Die?
are you, Judge?
I'm doing fine. Thanks for asking. Mr. Die, you're here represented by your attorney, Ryan Gertz, who's appearing via Zoom.
Yes, sir.
Mr. Gertz, how are you doing?
Great, Judge. How are you?
I'm doing fine. Thanks for asking. Now, Mr. Gertz, what is your announcement in Mr. Dye's case?
Judge, we just got a new offer from the state yesterday that I have not had a chance to discuss with my client yet. I'd ask for a resetting to that March 8th date. And
Okay.
hopefully we can get this resolved or put on the correct docket. So,
Okay, so this case is going to be reset till March 8th of 2023. Mr. Dye, you're gonna get your reset here in court.
Yes, sir.
Once you get your reset, you'll be free to go and stay in contact with your attorney. Please stand on the forex in front of our court coordinator.
Thank you.
And Mr. Gertz, your reset will be sent to you. This is the only case that you have here today, so you're free to go and you have a blessed day.
thank you, Judge.
Okay, you're welcome. And at this time, the court will be in recess. Yeah,
Does Mr. Smith need to be here?
yeah.
Let's get him.
Jefferson County Court, law number 2 is back in session. Next case is cause number 330610. Case is style of state of Texas versus Lee M. Smith or Lee Michael Smith. Mr. Smith, is that your full name?
Thank you, Your Honor.
How you doing, Mr. Smith?
Good, thank you.
That's good. Mr. Smith, you're here or represented by your attorney, Attorney Jack Lawrence. Attorney Lawrence, how are you doing?
Just fine, Your Honor.
That's good. Mr. Lawrence, what is your announcement in Mr. Smith's case?
All right, Your Honor, since Ray is no longer assigned this court, there's been a misunderstanding as to what we had agreed to. And the state doesn't want to go forward until they've got it straightened out as to what the agreement was. So we've agreed to a reset that, but it cannot go into April because of some other agreements that affect this. So we agreed to a reset into the end of February, or even better, the early March
Okay,
would be
so it's
better.
gonna be March 8th.
Yes, sir.
Okay, so this case will be reset to March 8th of 2023. Mr. Smith, your attorney, Mr. Lawrence, is gonna sign for your reset. Once you get your reset from your attorney, you'll be free to go and you have a blessed day. And Mr. Lawrence, would you please stand in front of the court coordinator on the far end, sign for the reset?
Thank you, Your Honor.
Okay,
Thank you, Your Honor.
all right.
wanted to, you could go to take the options back and, if you wanted to, execute a affidavit of
Non-prosecution, okay.
after that, then you could, but again, those were, up to her. We just gave her the option to take the options.
Okay,
back.
so y'all just need to verify whether or not she took the options class or whether or not she executed a affidavit of indigence.
Yes, sir. We have no record.
I mean, a affidavit of non-prosecution.
Yes, sir. We have no record that,
Oh, okay.
that had taken place.
Okay,
And Mr. Lindsay is here today too.
yeah, no, Mr. Lindsay, would you please come forward and make sure your phone is off? Okay, this is cause number 332-158, case of style of the state of Texas versus James Anthony Lindsay, or James Anthony Lindsay Jr., is that correct?
Yes, sir.
How you doing, Mr. Lindsay? You can't be better than that. Now, Mr. Lindsay, you're here represented by your attorney, Attorney Jack Lawrence. And now, Mr. Lawrence, you're gonna reset this case as well to that same date to give that state an opportunity to look into whether or not the complaining witness has taken the option class or whether or not the complaining witness has filed an affidavit of non-prosecution.
Your Honor, we could set it further down if you wanted to. I want to be sure to get a date that's convenient to his job that he holds.
Now, Mr. Lindsay, is March 8th a date that's not convenient with your job? It's 2 months out.
That's fine.
Okay. So this case is gonna be reset to March 8th of 2023. Mr. Lindsay, your attorney is gonna sign for your reset date. Once you get your reset date from your attorney, you'll be free to go and you have a blessed day. And Mr. Lawrence,
Yes.
you can sign for the reset with our court coordinator.
Yes.
Once you get your reset, you'll be free to go as well and you have a blessed day.
Thank you.
You're welcome. Good morning, Mr. Paget. Mr. Paget, we're in the middle of getting ready to do a sentencing.
Yes, Your Honor.
And could you just, we'll get to you once we finish the sentencing.
Yeah, I'll try to check back with you. My clients haven't been able to reach him in quite a while, but I'll hang around.
Okay. Okay, thanks.
Thank you. Bye-bye.
Bye. Mr. LeBlanc, just keep your mic on mute. We're getting ready to do a sentencing. Thank you. The Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 324446. Case of style of state of Texas versus Satchel Renell Lewis. We have Ms. Lewis present in court. Ms. Lewis, is your full name Satchel Renell Lewis?
Yes,
How you doing, Ms. Lewis?
I'm good, how are you?
I'm doing fine, thanks for asking. Ms. Lewis, you're here represented by your attorney, Attorney John West. Attorney West, how are you doing?
Good, Your Honor, thank you.
And the state is represented by Attorney Lamar Johnson. And Attorney Johnson, how are you doing?
Bless you, Your Honor, thank you.
That's good. Now, the court has before it a punishment hearing that's scheduled for the date. And just for the record, oh, hold on a minute. Jefferson County Court, Number 2 is back in session. Our next case is cause number 324-446, case of South State of Texas versus Satchel Raynell Lewis. Mr. Lewis, would you please come forward with your attorney, Mr. John West? State, would you please come forward? This case is set for a punishment hearing. The case was tried by jury on November 10th of 2022. The jury found Ms. Lewis guilty for the offense of assault, which is a Class A misdemeanor. And the court reset this case for a PSI, and court have received a copy of that PSI or pre-sentence investigation report. Mr. West, have you received a copy of the pre-sentence investigation report?
Yes, sir.
Did you review the pre-sentence investigation report?
We have, Your Honor.
Do you have any objections to the finding, conclusions, and recommendations in this pre-sentence investigation report?
No, Your Honor.
Any additions or deletions?
No, Your Honor.
State, did you receive a copy of the PSI report in this case?
Yes, Your Honor.
Do you have any objections to the finding, conclusions, and recommendations?
No objection.
Do you have any additions or deletions to this PSI report?
No, sir.
Okay, so at this time, the state will receive arguments as to what punishment should be. State, to give you an opportunity to go first.
Your Honor, the state believes that the punishment should be at a minimum 2 years of probation if the court is thinking probation with $1,000 fines and 100 hours of community service, Your Honor. If the court is inclined to go the probation route. If not, Your Honor, the state believes that jail time, 14 days jail time. If the court is not inclined to offer probation or probation, Your Honor, and the basis of it is just the heinous nature of this assault, Your Honor. Again, no need to rehash what's already in the PSI report. But at the time the defendant was pregnant, the time of the assault that she was found guilty for, the defendant was pregnant. She assaulted the victim here, Miss Amonique, at her home with her 2 children there. Outside her home, inside her home, Miss Amonique, Miss Ford had a black eye. She was bleeding. I think we all saw the picture during trial, Your Honor. Her 2 kids that were at the residence, 4 and 8 years old, they had to hear their mother being assaulted and had to run down to help them while they back upstairs. The victim in the case, Your Honor, was screaming so loudly during the assault that even a neighbor came over and tried to break the incident up. Because of that, Your Honor, and given the defendant does not have any lengthy criminal history or anything like that, Your Honor, but just given the heinous nature of this crime, that is the basis for the state's position as far as punishment.
Okay, now you stated, well, recommendation was like 2 years probation and $1,000 fine.
Yes,
Those
sir.
court costs. How many hours of community session?
100.
100. And
no contact with the victim.
Okay. And you also stated that the alternative is 14 days in the county jail?
Yes, sir.
Okay. Okay. Defense?
Your Honor, the court heard this case. The court was involved in this, did not make a guilt innocence decision, but was involved in the case, so it knows the facts of the case. Also, the court has reviewed the PSI. This, Your Honor, is a probation case. My client has no criminal history, is working, who has a productive life, productive member of society, whatever you want to call it. She's been doing what she needs to do. There was an issue between her and the victim in this case. I'm not going to rehash again, like Mr. John said, we're not going to rehash the issues there. But I think this is more appropriate of a year probation based on the facts of this case and the PSI and all the information about my client. So I would recommend 1 year probation, $500 fine, 40 hours community service would be my counter to Mr. Johnson's proposal, and no jail time. I think this is not the type of person that we put in jail. We see those quite often with this individual who's working, who hired an attorney, who came to fight this case. This is not someone who needs to be in jail. She has family, she has a job, she has all the things that she's trying to move on with. So that would be my recommendation.
Okay, now, is there anything your client wants to say? You want?
Absolutely. If she wants to say anything you want to say about this?
I think I'm just really shocked that I'm here. And I'm embarrassed that I'm here. And I just want to apologize to everyone in the court for even having to be here on my behalf. So.
Okay. All right. Now, the court has court is going to take judicial notice of the court's file. The court has read the PSI report. The court heard evidence that was testified to and brought up in the course in this case. I noticed that in Ms. Lewis's statement, she'd like to apologize to the court, but nowhere did she apologize to the complaining witness in this case, which shows that there is a lack of remorse in this case. And normally, as you know, Mr. West, and it's also Mr. Johnson, remorse is one of the mitigating circumstances. And so that is concerning to the court.
Can I respond to that, Your Honor?
Yes.
I think normally in PSIs where we have the remorse or whatever, and I understand that because we deal with that all the time, is that for cases where people plead guilty. In this case, my client still to this day maintains that she's not guilty. She was the victim in this case, and it was she was the victim and not the aggressor. And that's what the trial was about. So I think that's why there's no remorse for that case in that situation, because it's a little different than a plea bargain where somebody comes and says, Your Honor, I'm guilty, I'm sorry, I want to take the deal and move on. This is not that case. It's different. This is we went to trial, we were found guilty. Now we're here in front of the court for sentencing, not a pleading guilty and going to court for that. So I would agree with the court to an extent that normally the remorse is a big issue because that's one of the major things we look at. In this case was a trial where my client maintained that she was innocent, and still even today, even though she was found guilty, still in her mind believes that she's innocent. So I don't think the remorse should be held against her due to that factor, because it's different than an open plea or something like that, where the court normally takes that into consideration.
Okay. Now, in reference to you stated that she works. Is that correct?
Yes.
And how long has she been working at that job? Do you know?
I don't know for sure, but I can ask her how long you. Well, first of all, where are you working?
I work for a property management company. I manage about 400 units, and I am a realtor.
Okay, and that's all you have the shirt from your business today. Oh, okay. And how long have you been working there?
I've been working at my job for about a year. I've been a realtor full time for 2.5 years.
Okay. Okay. Now, I did look at the, as you stated, the criminal history. She does not have any convictions on a criminal history. I do note that it was a deferred prosecution, and I guess that was a juvenile situation. So as an adult, she doesn't have any thing on her record other than this charge for assault and maybe 2 traffic violations. Is that correct? According to PSI?
I guess that sounds right.
That's the extent of it.
Yeah.
Now, there is some concerns that the court has with regards to there may have been some allegations of contact that Ms. Lewis has been accused of in this PSI report. in contact, we're saying contact with, complaining witness and maybe some, family members. Now, that is also concerning, with the court. The other thing is, okay. Okay, now this is a first degree, well, not first degree, this is a class A misdemeanor. And the range of punishment for a class A misdemeanor is anywhere from 0 days to 365 days in the county jail, a fine from $0 to $4,000. You could be also given probation in this case. And so now, this is what the court is going to do. Okay. The court is going to accept punishment at 2 years. 365 days probated for 2 years in the county jail. Okay, that simply means that you'd be on probation for 2 years. The fine in this case is going to be $2,000 plus court costs. And you will be assessed 100 hours of community service. The defendant shall not communicate. You cannot have any contact with the complaining witness. You cannot communicate with the complaining witness either directly or indirectly with the victim in this case. And you shall not go near any residence, school, or other location frequented by the alleged victim. Okay? So you cannot have any contact. And when I say no contact, not only talking about physical contact, we're also talking about social media. Okay? No contact and no indirect contact. If you try to make contact indirectly through somebody else, that would be a violation of your probation. Okay? And the other thing is, you'll be required to attend anger management classes. Okay? And now the court is going to require that as a condition of probation, 15 days upfront jail time. However, the jail time is going to be held in abeyance. And then what that simply means, if you do something to violate your probation, you're going to do 15 days upfront in jail. Okay? Make sure I've done. Also, I guess they're gonna have a standard condition of probation. They have a number, I think they have a curfew. It's 10 p.m. to 6 a.m. And probation, you don't live here in Jefferson County, right?
I do not.
Okay, so your probation could be transferred, to, where you live?
Harris County.
Harris County? Okay, so you can report there, but you have to start here in this county, they have to transfer it to Harris County.
Yeah, I explained that to her Right here.
You there?
Yeah, we talked about it.
Okay, and this is the order of the court. Okay, now, Miss Lewis, just have a seat. She has to draft up the judgment. And once that hold on a minute. We also, did y'all sign the, y'all have to, Mr. Y'all gonna have to fill this out. Just check off the box that's appropriate.
Right. That's it, yeah, yeah. That's it.
Hmm,
She's already signed it. I think we just checked that one box that she has the right to appeal.
okay. Okay, this is the order of the court. Y'all just have a seat and then she's gonna draft up the,
Thank you.
okay, you're welcome. Court is now in session and calls number 323-227 and calls number 332-425. Case style of the state of Texas versus Samuel Hayden Falk. Mr. Falk, would you please come forward?
Yes.
Mr. Falk, is that your full name, Samuel Hayden Falk?
Yes, sir.
How you doing, Mr. Falk?
Pretty good. I got stuff.
I'm doing fine.
Happy New Year's.
Oh, a happy New Year's to you too. Could we check and see if he has bond conditions in his first case?
I do have one condition.
Okay.
Yeah.
They normally put it on the docket sheet. I didn't see it on the docket sheet. Now, Mr. Falk, I see here that the last time that you hear your case was reset to give you an opportunity to hire an attorney.
Yes, sir. Well, it was a dissolution. I'm sorry, I can't remember exactly which word you used, where you just separate from your attorney. legally, like,
So your attorney withdrew?
we withdrew from each other, yeah. Bruce Smith,
Okay, and then you were supposed to hire another lawyer?
correct. And I contacted a doctor, Mr. Gilmore's office, and apparently his
Justin Gilmore?
yes,
Galmore?
Galmore.
Yeah.
And he referred me to his colleague because his case was so high. And I just recently heard back from his colleague, and he said that he feels my case is complicated. So he referred me to someone else just recently, but I don't think we're gonna go with that person that he just recommended. We're gonna contact a family member who has connections to Provost and Upland. So
Okay, now,
But
Mr.
with the New Year's, it's been kind of,
Well, I understand that, but
Yeah.
Mr. Falk, I'm looking at your cases. The first case is a real old case.
it's almost 4 years.
Right. So the court doesn't, the court is giving you as much time as possible. I know you had an attorney, your attorney withdrew for whatever reason. But he's no longer on your case.
Correct.
But the cases need to get resolved.
I concur.
Yeah, okay, well, I'm glad you concur with that.
Yeah.
Because the case is gonna get resolved pretty soon. I'm only gonna reset this case 30 days to get you, so you get a lawyer.
I appreciate that.
If you don't have a lawyer by then we're gonna have to just continue we're gonna go forward.
I understand.
Okay, give us a reset date, 30 days?
Thank you.
No, that's too far.
I appreciate it. Thank
Give
you.
us, we don't have nothing in January? Put him in January. No, put him in January. Well, yeah, you can put him in February. That'd be fine. First week in February.
Okay.
We'll just put him on the 8th. These cases are gonna be reset to February 8th of 2023. Give you time to hire your attorney. Court is not giving you any more extensions. So
Okay.
you need to have your attorney in place by that time.
That was one of the problems that I was having with Mr. Smith is
Well, let me do this here.
not being
Mr.
here.
Smith is no longer your attorney.
Good.
He's been withdrawn. He's been relieved from the case. The court is not going to entertain any
Excuse.
conversation, any thing that any problem that you have that you had or have
That's
with your former attorney. Okay.
Gotcha.
So right at this point, the court is just interested in going forward, and so we can get this case resolved in a timely manner.
Thank
Okay?
you.
Please stand on the 4X.
I
Get
appreciate
your
it.
reset. Once you get your reset, you'll be free to go and you have a blessed day. Yes, Mr. Cole. Is that Olympia Lamel?
Yes, yeah.
Why don't you go get Miss Lamel?
She's, I don't know, born to turn herself in.
Oh, she got a warrant. Okay.
And so
Oh, is she here?
she is here, but her daughter's with her and they need to facilitate a few things, get to the bondsman and
Well, I don't know about all of that. If she's here and we got an active warrant, she's gonna be taken into custody.
well, she,
That's how that works.
I understand, Your Honor.
Okay, this is cause number 330-722, case of style of state of Texas versus Olympia Lamel. Miss Lamel, is that your full name?
Yeah.
How you doing, Miss Lamel? I'm doing fine. Thanks for asking, Miss Lamel. You're here represented by your attorney, Attorney Giles Cole. Attorney Cole, how are you doing?
Great.
Okay, and Mr. Cole, what is the announcement in Miss Lamel's? I see she has a felony.
Yes, Your Honor.
Is that correct? Okay, that's the one that's,
Yes.
there's a warrant out on that one. Okay, so, what we normally do is reset the misdemeanor, well, depending on how do you want it, set?
Attract it.
You wanted to track the felony state, you have any objection?
No objection, Your Honor.
Okay, because I think usually the state does the same. So what we'll do, we won't give her a court date right now because she has to be taken into custody because there is a felony warrant out. And so you're gonna follow the bailiff, he's gonna take you into custody. And then when the case is reset, we're gonna reset it with the felony case, once you get out, okay? All right, just please, just have a seat in the jury box.
Thank you.
Okay, you're welcome. We have a plea ready? No, no, what's that? You have to put it that she cannot go on to the chair. I don't know how much space you have in there. But she it's your part. You could put your bag. Okay. This is a city appeal. Okay, this is cause number 331-297, case of style state of Texas versus Karen Bushin. Ms. Bushin, is that your full name?
Yes, sir.
Okay, how are you doing, Ms. Bushin?
I'm good. How are you?
I'm doing fine. Thanks for asking, Ms. Bushin. I see here that this case was a case that was transferred from County Court at Law number 3,
Yes, sir.
and it is a city appeal. Is that correct? Now, does she have any judge's explanation of rights to defend us without attorney in the file? Okay, now, Mr. Bailey, would you please hand her a judge's explanation of rights to defend us without attorney? Okay, now, Ms. Bushin, you've just been handed a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you see that document?
Yes, sir.
I'll go over this document with you. As a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, you may not speak to the prosecutor, that is, assistant district attorney who's handling the case, about your case unless you sign a written waiver of your right to be represented by an attorney. And that waiver is usually attached to that document, and the waiver is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding the trial. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, at the bottom of that document, in bold print, it says defendant's choice. Mark initials next to only one choice. If your choice is you want to have this case reset or so that you can hire an attorney, you'll place your initials on the first line to the left. If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, which means if you want to give up your right to an attorney and represent yourself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line where it says defendant, and you will date it today's date, January 4th of 2022. Do you understand? Excuse me, 2023. And do you understand?
Yes, sir.
Okay. Would you like to make your choice now?
Yes, sir.
Okay. Does she have a pen?
I do.
Okay. Oh, she got an X. She got to put her initials on it. Okay. Now she has to sign that, yeah. Okay, I'll go over that with you too. Now, Ms. Boshin, the next document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And this document states that I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 4th day of January 2023 by the County Court of Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to employ counsel or afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign where it says defendant, and you will date it today's date, January 4th of 2023. Do you understand?
Yes, sir.
Okay, you may make your. Come on, for red warning. go. Okay. Now, this motion, I have before me a document. Well, actually, I have two documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. And the second document is waiver of counsel for purposes of entering guilty plea proceeding at trial. Now, the judge's explanation of rights to defendants without an attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that states I want to waive my right to an attorney and represent myself? And on the next document, this title, waiver of counsel for purposes of entering guilty plea or proceeding to trial. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Ms. Motion, before you signed and initialed these documents, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes,
Okay. Now, Ms. Motion, I need to ask you some questions. This is pursuant to the case of Ferretta versus California, 422, United States, 806 of 1975 case. A couple of questions I need to ask before we can go forward. So the court has to determine whether or not you should go forward and represent yourself. Number one, have you ever studied law?
Yes, sir.
Okay. Have you ever represented yourself in a criminal action?
Yes, sir.
Do you understand the charges against you?
Yes, sir.
Are you aware of the maximum punishment for that charge? What you can get?
I'm really sorry.
Okay. Now, are you familiar with the exact legal elements of the charge?
Yes.
And now, do you realize that if you represent yourself, you are on your own?
Yes, sir.
And as a judge, I cannot tell you how you should try your case or even advise you as to how to try your case.
Yes, sir.
And I cannot help you in any way.
Yes, sir.
Are you familiar with the Texas rules of evidence and Texas case law?
I've reviewed them, yes, sir.
Okay. Do you realize that the Texas rules of evidence and Texas case law govern the evidence, how evidence, what evidence is admitted? And representing yourself, you must abide by those rules.
Yes, sir.
For example, let me ask you this question: How do you conduct a voir dire examination?
I'm not real familiar with it.
Okay. Okay, voir dire is how do you pick a jury? Okay. Now, what are the grounds for excusing? Are you aware of what are the grounds for excusing a juror for cause?
Yeah.
Do you know what hearsay is?
I believe so.
What are some of the exceptions to hearsay?
Just an exception would be, like if somebody else heard you say something and then they were asked to say what they heard.
Okay. Do you know what proper impeachment of a witness is?
Yes, sir.
Do you know when character evidence is allowed?
Yes, sir.
Do you know when and how to make a proper objection?
No, sir. No.
Do you know how and when to move for a directed verdict? Do you know how to offer or proffer evidence to protect the record for appeal? Do you know the proper grounds for mistrial?
Yeah.
Are you aware that failure to timely move for a mistrial may waive crucial mistakes made by the state or this court?
Am I aware of it?
Yes.
I believe so.
Do you know how to request and object to a jury instructions?
Yes, sir.
Are you familiar with the Texas rules of criminal procedure?
not very familiar.
Do you realize that those rules govern the way in which a criminal action is tried in court?
I'm aware of it, yes, sir.
Now, I must advise you that, in my opinion, you would be far better defended by a trained lawyer than you can be by yourself. I think it is unwise for you to try to represent yourself. You're not familiar with the law, you're not familiar with court procedures, you're not familiar with the rules of evidence, and I would strongly urge you not to try to represent yourself. Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by an attorney?
I don't want to sound out of place. Well, but I am, but since I am pro se, I wanted to may I ask you a question?
Well,
Not regarding anything that we just talked about.
well, let me do this here. Now, the question that I just needed, could you give me an answer to the question that I just asked you?
Sure. I am. I don't know how to answer that.
Let me ask you, is this your first court appearance here?
In this court, it is number 2.
Right.
And number 3 was, because we've been reset for over a year now. 4 different times. And so now you have us. And what I wanted to say, then I'll just say it.
Now, let me do this here before you say anything. You have a right against self-incrimination. Anything that you say can and will be used against you in a court of law. You have a right to have an attorney. Before you make any statements, or even before you question, so you have a right to have an attorney, and right now the court is trying to determine whether or not you want to hire an attorney, whether or not you want to see if you qualify for a court-appointed attorney, or whether or not you still would like to or represent yourself in light of all of the previous questions that the court has asked you.
Yes, sir. And my answer to that is going to be, I am going to be pro se. Because
So you're saying that now the decision for you to be pro se is entirely voluntarily on your part, is that correct?
that's correct.
Okay, so I find that the defendant has knowingly and voluntarily waived her right to counsel, and I will therefore permit her to represent herself in this case. Now, at this time, Ms. Beauchamp, what the court is going to do is, because the case was just transferred over here from the previous court, we're going to reset this case. Now, we can reset it for what we call an announcement. What an announcement is, you will come back to the court and tell the court whether or not you want to go to trial or whether or not you want to enter a plea to the case. Now, in between that time from today until you come back for your announcement, you will have a right to have what is called discovery. That means that you'll have a right to have access to the evidence that the state has against you. Now, because you are representing yourself, you need to make arrangements with the assistant district attorney so that they can allow you to have access. And then once you get access, review the evidence, and you'll be talking to the prosecutors because you're representing yourself. Then when you come back on the announcement day, you'll tell the court what you want to do.
Yes, sir.
Okay?
Yes, sir.
So at this time, your case is going to be reset for an announcement. Could you give us an announcement date? You said the case could be reset either March 8th or March 15th, depending on what is better with your schedule. Which, the 8th? Okay. So this case will be reset to March 8th of 2023. You're gonna stand in front of our court coordinator to get a copy of your reset. Once you get a copy of your reset, you'll be free to go and you have a blessed day.
Yes, sir.
Okay,
Thank you.
you're welcome. We have anybody ready? Did you finish yours? So I'm saying you need to bring her up to do all the prints, huh? Yeah. Yeah. Yeah, oh. I just want to add that, okay. Okay, yeah. Read. Oh. I got it. Ms. Adams, you ready on read?
Yes, we're ready.
Okay, y'all come forward. Jefferson County Court at Law number 2 is back in session in clause number 325882 and clause number 326720. Both cases are styled the state of Texas versus Shannon Rodriguez Reed. Mr. Reed, is that your full name?
Yes, sir.
How you doing, Mr. Reed? That's good. Mr. Reed, you're here represented by your attorney, Mr. Langston Adams. Mr. Adams, how you doing?
Doing well.
Now, Mr. Reed, would you please raise your right hand? Mr. Reed, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mr. Reed, you may put your hand down. Mr. Adams, do you waive a record in Mr. Reed's case?
Yes, sir.
Mr. Reed, in cause number 325882, the court has before it information. This information was filed by the Jefferson County District Attorney's Office. This is some information alleges that on or about January 30th of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest detention. Mr. Reed, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Reed, how do you plead? Guilty, not guilty, no contest? No contest, and are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charge?
Yes, sir.
Mr. Reed. I also have before me a document that is titled misdemeanor plea admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials on the line. The initials of DR, they're on the line. It looks like a DR. Is that an R? Okay, SR, that's on the line next to the box that's check no contingency, no contest. Do you recognize these initials?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
On the next document, which is titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled defendant?
Yes, sir.
There are 2 boxes that checked at the top of this document. The first box is checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
I also have a document that is titled discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes.
Now, Mr. Reed, before you signed and initialed all of these documents that I just mentioned to you, did your attorney, Mr. Adams, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment, and State's Exhibit Number 2 in the court's file, the probable cause affidavit. State, you'd like to offer States 1 and 2?
Yes, Your Honor. State offer State 1 and State 2.
Any objections?
No.
No objections. State's Exhibits 1 and 2 are admitted. Mr. Adams, you advised and counseled Mr. Reed, is there any evidence that he is currently mentally incompetent to stand trial?
No.
Mr. Reed, your attorney, Mr. Adams, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Reed, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of waivers was freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, in exchange for defendant's plea of no contest in this case, the state is recommending confinement in the Jefferson County Jail for a period of 90 days, Your Honor. We're asking that the court suspend imposing that sentence at this time and instead place defendant on community supervision for a period of 1 year. Your Honor, require defendant to pay $500 fine, to complete 30 hours of community service, and to complete a death class, Your Honor. And in connection with this plea agreement, the state is moving to dismiss companion case number 326-720.
Okay, now, Mr. Reed, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail because you will be placed on probation in this case for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $412, which comes to a total of fine and court costs of $912. You'll also be required to pay a probation fee of $60 each month, or your analysis fee of $15 each month. You'll also be required, now you'll be required to reimburse Jefferson County Court appointed attorney's fees of $250, and you'll be required to pay this back in monthly installments of $185 a month. Now, will you be able to pay the $185 each month? Now, you will also be required to perform 30 hours of community service, attend and complete a theft class, as you will also be required to adhere to the other standard terms and conditions of your probation. The state will be dismissing the theft case in this the companion case, the theft case, in cause number 326-720. Mr. Reed, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Reed, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Reed, you're gonna stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go. Over here, Mr. Reed. You'll be free to go, and you have a blessed day. And before you leave, we're gonna give you a copy of the dismissal. Next case is cause number 329-984, case of style of state of Texas versus Catlin G. Moore. Mr. Bailiff, would you please call the name of Catlin G. Moore at the courthouse door? And okay, Catlin G. Moore was scheduled to be in court for 9 a.m. on today's date, which is January 4th, 2023, for the announcement docket. At about 9 a.m., Catlin Moore's name was called at the courthouse door. Catlin Moore did not answer. Catlin Moore has not appeared in court since the court's been in session. Catlin Moore is represented in this case by his attorney, Attorney James Padgett, who is appearing via Zoom. Mr. Padgett, Mr. Moore is not here.
Your Honor, I'm also representing Mr. Moore in Orange County. He did not show up for his scheduled court appearance last month either. I've been unable to reach Mr. Moore for the past month to a month and a half. I've done everything in my ability to get him into my office to discuss this case. All the phone numbers and ways I've even contacted his bonding company. I've had no luck reaching him. My plan is to go ahead and e-file a motion to withdraw just to have it on file. And when he is taken into custody, we'll address the issue again.
Okay. Now.
When and if I can't locate him.
Okay, now the bailiff just called Mr. Moore's name again. He did not answer when his name was called at the courthouse door. State, do you have a motion?
Yes, Your Honor, state move for bond forfeiture.
That motion will be granted. Caitlin Moore bond will be forfeited and a warrant should be issued for his arrest and cause number 329-784. Mr. Paget, thanks for being patient with us. You're free to
Yes,
go,
sir.
and you have a blessed day.
Thank you, Your Honor. Have a great day.
All right, thank you. Court is in session and cause number 326-354, case of style state of Texas versus Samantha Nicole Jones. Samantha Jones is scheduled to be in court this morning for the court's announcement docket at 9 a.m. on today's date of January 4th, 2023. At or about 9 a.m., the court's bailiff called the name of Samantha Jones at the courthouse door. Samantha Jones did not answer. Samantha Jones has not appeared in court since the court has been in session. However, Samantha Jones' attorney, Mr. Ryan Matuska, is present in court. Mr. Bailiff, would you please call the name of Samantha Jones at the courthouse door?
No response.
Samantha Jones' name was just called again at the courthouse door by the court's bailiff. The time now is 11:28 a.m. on today's date. State, do you have a motion?
Yes, Your Honor, state move for bond forfeiture.
That motion will be granted. Samantha Jones' bond will be forfeited and a warrant should be issued for her arrest in clause number 326-354. And Mr. Matuska, you are excused.
Thank you, Your Honor.
Huh? Oh, I just need to. Oh, I just need to change that to, God, though. I gotta change it to 2023. Oh,
Yeah, one more person.
huh?
One more person.
Okay. Next case is cause number 332-784, case of style state of Texas versus Martell James Francois Jr. Please come forward. I just need to. Just do that. Mr. Francois, your full name? Martell James Francois Jr. Mr. Francois, how are you doing? I'm doing fine. Thanks for asking. Mr. Francois, Last time you was here, your case was reset to give you an opportunity to hire your attorney. Have you hired your attorney?
I'm still looking. I was just talking to Mr. Adams.
Okay, how much time do you need to hire your attorney?
Like 2 3.
Are you working?
I'm still not right now.
I mean, how you expect to hire an attorney if you're not working?
I'm looking for a job right now. I've been filling out applications. I just filled one out. Exactly.
For Zachary?
Yes, sir.
Okay, now this case is not an old case, it's relative. Now, you've been here one time before,
Yes, sir.
so this is only your second time here.
Yes, sir.
Okay, let's give him a reset to hire. Which date is March 8th or March 15th?
It don't matter. It's up to y'all, sir.
Well, just give him 15th. You said you needed about 2 to 3 months, right? Okay, give him March 8th, what's the March 15th, okay? We'll give you the March 15th, 2023 to hire your attorney. You're gonna stand on the X in front of our court coordinator. And she's gonna reset your case. Once your case is reset, you'll be free to go and you have a blessed day.
Yes, sir. You too.
All right.
Yeah.
Okay.
Ferguson and